Hello, Cisco Unity Connect. Hello, Cisco Unity Connect.
All right, I'll try one more time. If we're unable to get them, we may have to get them as well. Maybe recall them tomorrow. I mean, you can get them. You can get the interpreter on. It's possible.
Hello, Cisco.
All right, we'll recall the interpreter cases after a while. Is anyone else ready? Is Kevin Rivera available, or he refused? All right.
Defense will waive his appearance, Your Honor.
I'm sorry?
The defense will waive his appearance.
Okay. Thank you. All right, so in case number 2021 CF 11872, the court has reviewed the charging affidavit in terms of establishing an appropriate bond and release conditions. Prior judge found probable cause and issued a warrant. I'm going to set bond on count 1 at $5,000, count 2 at $1,000, count 3 at $500. Conditions of bond will be maintain a separate residence. The defendant may return one time with law enforcement to obtain personal belongings, may not have any contact with the listed alleged victim, and may not possess any weapons or firearms. In case number 2021 CF 14142, another judge has found probable cause, set bond at $25,000 on count 1 and $5,000 on count 2. And I'm going to stay those bond amounts based on the circumstances of that case. Case number 2021 CF 898. Capias was issued after failure to appear at trial case management conference on October 14th. Lease was revoked and there is 0 bond on that case. Case number 2020 CF 9012. There was a violation of probation warrant issued in that case by Judge Wilson. There is no bond in that case. Case number 2020 CF 9012. That's the same case I just called. I'm not sure why I have 2 affidavits there. There may have been, let's see what the affidavit was. I'm going to take no action on the on view, given that there's an affidavit. DOC can file an amended affidavit if they wish. Yeah. It's the same case. So he's being held on zero bond on that case. No. That's I'm treating that as a supplement to the warrant that Judge Wilson. Yeah, that's fine. And then on case number 2021 CF 14148, I reviewed the affidavit. I do find probable cause. I will stay the bond at $1,000. Okay, anything further on those cases, counsel?
No, Your Honor.
All right, thank you, sir.
Judge.
Yes. I don't see an affidavit here. Some of these had affidavits. So yes, he is entitled to be represented by counsel. So I will provisionally appoint the Office of the Public Defender to each of the cases. Do we have Mr. Saab or Mr. Steplight?
Yes, we do, Your Honor.
Okay, who's this? Okay, let's go ahead and take, this is Emily Schmidt.
Please and thank you, sir.
I'm sorry?
I said, please and thank you, sir.
All right, so we're going to go ahead and take Ms. Schmidt's case. All right. All right, ma'am, you're entitled to be represented by a public defender, well, by a lawyer. There's not a check mark on indigent, but there is a check mark by the public defender is appointed. Did she qualify for representation by the public defender?
Yes.
Okay, so let me place a check mark in that box. Ma'am, would you like for me to appoint the public defender to represent you?
Yes, sir.
All right, I will do that. All right. I reviewed the affidavit, ma'am. You're charged with aggravated battery with a deadly weapon, domestic violence. I do find probable cause. I'm going to set your bond at $2,500. I'm going to order that you have no contact with the listed victim. Going to order that you may return one time with law enforcement to obtain personal belongings. You may not reside with the listed victim. You may not possess weapons or firearms while this case is pending.
Okay.
Okay? Anything further, counsel?
No, Your Honor.
Thank you. All right, let's call up Mr. Saab next. Thank you.
And Your Honor, for further consideration of the court, I'm almost willing to bet that there may be some mental health issues going on with Mr. Saab. That's another reason why I would ask for the ROR in this case.
Good afternoon, Mr. Saab. All right, so Mr. Saab, good afternoon, sir. You were arrested, sir, for trespassing on property after a warning. I reviewed the affidavit of arrest, and I do find probable cause. You're entitled to be represented by a lawyer, and I'm going to provisionally appoint the public defender to represent you.
Trespassing is for an abandoned structure. That's not.
Well, sir, don't talk about your case because we're being recorded, okay? And the state can use your comments against you, okay? So please don't talk about your case. There is no Florida history. There is a history elsewhere. Mr. Saab doesn't have much in the way of ties to the community as far as I can tell based on what's in front of me. On the other hand, these charges are relatively minor, and Mr. Saab does seem to be a person of few means. He does not qualify for PTR. Based on the totality of the circumstances, I will grant ROR. All right, and is there anything else, counsel, I need to address?
No, Your Honor.
All right, thank you, sir. Is Mr. Steplight, there he is, okay. Good afternoon, Mr. Steplight. Sir, you were arrested on a warrant. A probable cause has been found. You're entitled to be represented by a lawyer. You do qualify for representation by the Public Defender's Office. Would you like for me to appoint that office to represent you?
Yes, sir.
All right, so I will do that. Your bond, sir, is set on count 1 at $2,500 and on count 2 at $50,000. I'm going to stay those amounts based on the circumstances described in the warrant, and you may not possess any weapons or firearms as a condition of your release in this case. All right, anything further, counsel?
No, Your Honor.
All right, thank you, Mr. Steplight. Let me try the interpreters again. Let's see if we can get them before we bring anyone inside.
Hello, Cisco Unity Connect.
All right, we'll try again in a few minutes. Let's go ahead with the next case. That will be John Yee. Good afternoon, Mr. Yee. I have a question for pretrial release. Is this direct pretrial release or pretrial release requiring a bond?
It's whatever you decide, Judge, but now you know he does qualify for pretrial.
Okay. I noticed the forms here look a little different than the Osceola forms, that's why. Okay.
Just now you know that he does qualify.
Okay, thank you. Mr. Yee, you were charged with battery, domestic violence. Actually, battery by strangulation. I've reviewed the affidavit. I do find probable cause. Do we have someone to testify? Okay. Ma'am, can you hear?
Yes, sir.
All right, please raise your right hand to be sworn. Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I swear.
All right, thank you. Tell the court what you would like for me to consider.
I would be satisfied with conditional release with no contact, sir.
So you don't believe monetary bond is necessary, but you wish for the court to order no contact?
If possible, sir, yes.
Okay. State, do you have questions?
Your Honor, may I inquire?
You may.
Can you please state your name?
Jenny Yi,
And what's your relationship to the defendant?
sister.
Are you afraid of the defendant?
No,
Has this happened before?
physically, no.
Are you willing to call 911 if anything were to happen in the future?
Yes, ma'am.
Do you believe there were any drugs or alcohol involved in this incident?
No, ma'am.
Do you want to have contact with the defendant?
No, ma'am.
Nothing further, Your Honor.
Do you have questions?
No questions, Your Honor.
Ma'am, I have one question for you. At the time of this incident, you were living together. Do you still live together?
We are working on getting him out of our apartment, sir.
So you share an apartment? Are the two of you the only ones who live there?
No, sir, we live with our mother.
Would one of you stay there and one go somewhere else? What's the plan?
The plan is for him to move out, sir.
All right. Thank you, ma'am. All right, so based on the circumstances of this, this case that I read in the affidavit, and based on the fact that Mr. Yi qualifies for pretrial release, I'm going to grant pretrial release with the following conditions. You may not have contact with the alleged victim. You may return to the residence one time with law enforcement to obtain personal belongings. You must maintain a separate residence, all right? And you may not possess any weapons or firearms while you are on release, okay? And I believe I did appoint the public defender. Anything else, counsel?
No, Your Honor.
All right, thank you. Jaziel De Jesus? All right, good afternoon, sir. Do we have a witness on this case? All right, sir. You're arrested for battery, domestic violence. I have reviewed the affidavit and I do find probable cause. You're entitled to be represented by a lawyer. You do not qualify for representation by the public defender's office according to the documentation that I have. But you are entitled to representation by a lawyer. So you can hire counsel if you wish. I do find probable cause after reviewing the affidavit. You do qualify for pretrial release. I will grant pretrial release subject to the following conditions. You may not have contact with the listed victim. You may return one time with law enforcement to obtain personal belongings. You must maintain a separate residence because there is a permanent injunction in place, all right? And according to the affidavit, you've been served with that now. So that's part of the reason for these conditions on your release. And you may not possess any weapons or firearms while this case is pending. Okay?
Yes, sir.
All right, thank you, sir. Cassidy Eller.
Yes, sir.
All right. Ms. Eller, you were arrested for battery, misdemeanor battery.
Yes, sir.
I've reviewed the affidavit. I do find probable cause. You're entitled to be represented by a lawyer, and you qualify for representation by the Public Defender's Office. Would you like for me to appoint that office?
Sure.
I'm sorry?
Sure.
Okay.
That's fine.
So I will appoint the Office of the Public Defender to represent you. You are out on probation in 2019 MM 9562. So based on this arrest and the probable cause, I am going to find an on-view violation of probation, order that you be held in that case on zero bond. Anything further, counsel?
No, Your Honor.
All right, thank you.
Thank you.
On the original, maybe I did not announce the bond on the original. Can we bring her back in? All right, sorry, Ms. Eller, I let you go a little bit too soon. All right, so I need to set bond. I'm going to set bond on your new case in the amount, you don't qualify for pretrial release, so I'm going to set bond in your new case at $500. You may not have contact with the listed victim. You may not reside there, so I'm going to order that you maintain separate residence. You may return one time with law enforcement to obtain any personal belongings, okay? And you may not possess any weapons or firearms while this case is pending, okay? Thank you.
Is this the only case that I have right now?
You have the probation case as well.
Okay, but am I able to get out?
No, not in the probation case. The judge in that case might give you a bond, but you'll have to go see that judge, okay? And your attorney can help you get that case teed up.
Okay.
Okay, thank you. Okay, Facile Kadaine?
Yes,
Did I pronounce your name halfway correct?
you did.
Okay, thank you, sir. All right, sir, you were charged or arrested with battery domestic violence. I did review the affidavit, and I do find probable cause. Is this witness from the case? Okay. Ma'am, raise your right hand to be sworn. Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I swear.
Okay, state, go ahead with your inquiry.
Good afternoon, ma'am. Can you please state your name?
Vasquez-Rosado.
What is your relationship to the defendant?
Fiance.
Are you afraid of the defendant?
Yeah.
Has something similar happened before?
A lot of times, yeah.
Are you willing to call 911 if anything were to occur in the future? Do you believe there were drugs or alcohol involved in this incident?
No.
Do you want to have contact with the defendant?
No.
Nothing further, Your Honor.
Mr. Thompson?
Your Honor, I have no questions. I just want to point out to the court that he has no criminal history whatsoever. This appears to be a first offense, and he's 52 years old. We would just ask for a straight pretrial release and a no contact order.
And he has long-term employment, I noticed as well. All right. All right, so, ma'am, I have some questions for you. Do you reside together?
Huh?
Do you reside together with
What do
Mr.
you mean?
Kadaine?
What do you mean?
Do you live together?
Yes, we do live together.
Okay, and if I require that Mr. Kadaine maintain a separate residence, are you going to be able to pay for your mortgage or rent?
What I want now is I want to sell the house and then take his name out and my name out so we can be moving forward, live our separate life.
All right. Are you employed?
We're going back now, slowly. I work for the hotel.
Okay. All right, so I did find probable cause. Mr. Kadaine, you are entitled to be represented by a lawyer, as I said before, or maybe I didn't say. This says that this says you do qualify for representation by the Public Defender's Office. Do you wish for me to appoint that office to represent you?
Sorry, I didn't hear.
Yeah, would you like for me to appoint the Public Defender's Office to represent you?
Yes.
All right, so I will do that. Based on the history and the information I have in front of me, I'm going to grant pretrial release. That's non-monetary release with supervision by the pretrial release division. The conditions of your pretrial release, in addition to the reporting requirements, will be that you maintain a separate residence. You may return to the home one time with law enforcement to get your personal belongings. You may not have any contact with the listed victim. That means you may not, no communication through third parties, social media, email, text message. If you share children in common, you will have to arrange for child visitation and custody issues through third parties, okay? And you may not possess any weapons or firearms while you are subject to this case, okay? Thank you, sir.
I have a question.
Don't talk about your case, but what's your
No, it's
question?
not about the case. I need to get back to the house to pick up my uniform since I have to go back to work.
Yes, I said you can go one time with law
Should
enforcement.
it be tonight, though?
I don't know what time you're going to get out today, and I don't know how quickly law enforcement would be able to arrange something. Let me ask you this. Do you work tonight? Do you work tomorrow?
I'm supposed to work tonight as well as tomorrow morning.
Okay. So is there a person who lives more than 500 feet from your house that the alleged victim could deliver your uniform to, and you could pick it up at someplace else? All right.
Will I be able to get into the house without her present?
Well, no contact means you can't be within 500 feet of the residence, but counsel, what's the state's position?
Your Honor, the state requests that the defendant go to the house with law enforcement. As long as he goes to the house with law enforcement, I think that that'll be appropriate.
The issue is, can law enforcement coordinate that quickly? And this gentleman has a job. We don't want to put his job in jeopardy. That doesn't really help anyone. Mr. Thompson, what's your input?
Well, Your Honor, if there's a no contact order on the alleged victim, if she's not at the residence and he comes there, he's not really in violation of that no contact order. Because if it's his house too, I don't see how they could restrict him from not going back to his own house, Your Honor.
Well, the no contact means not within 500 feet of the residence where she lives. It's not really a matter of ownership. Ma'am, is there any reason, do you know what uniform he needs for
Yes.
work?
Yes.
Do you know all of the accessories he would need as well?
Yes.
Is there any reason you could not place those in a do you believe that you would be safe if you place those items in a plastic bag on the front porch?
Yes, I can do that.
I'm sorry?
I can do that.
Okay, you're willing to do that? You don't feel unsafe?
No, I can do that.
Okay. So I will let you go one time to get your stuff for work, and then you'll have to arrange with law enforcement to go back another time to get other personal belongings from inside.
Perfect. And my vehicle is parked right in front of the house as well. And my keys are inside the house as well.
All right, can you place his keys with his items?
Yeah, I can do
Also, I did leave an envelope yesterday with the officer. Did you receive the
that in
envelope?
there too.
Envelope.
All right, sir, sir, don't talk. I'm already bending the rules by giving you these things, because I want you to keep your job, all right? So, all right, so contact law enforcement as soon as you're out so you can arrange that one-time return to get all of your things, okay?
Perfect. Thank you.
All right, thank you.
So much.
All right, the next case, Gustavo Devorah. Good morning, good afternoon, sir. Sir, you were arrested.
This, Mr. Lee?
Oh, this is Lee?
Yes, sir.
Oh, sorry. Mr. Lee, I apologize.
You're fine, Your Honor.
So you were arrested for battery, misdemeanor battery. I find probable cause after reviewing the affidavit. You're entitled to be represented by a lawyer, and you do qualify for representation by the Public Defender's Office. Would you like for me to appoint that office to represent you?
Will that be done today?
I'm sorry?
Will that be done today?
It won't be done today. This is your initial appearance, but you're entitled to be represented by a lawyer throughout your case. You do qualify for representation by the Public Defender's Office. Would you
Yes,
like
sir.
for me to appoint them?
Yes, sir.
All right. You do qualify for pretrial release. So I am going to grant release subject to the following conditions. You may not have contact with the listed victim while this case is pending unless the assigned judge modifies that no contact order. You may not reside together, so you must maintain a separate residence. If you reside together and have items at the residence, you can go one time with law enforcement to obtain your belongings.
Yes, sir.
And you may not possess weapons or firearms while the case is pending, okay?
Yes, sir.
All right. Thank you, sir.
Well, I know that wouldn't be tonight, so I have to call law enforcement to arrange. Okay.
Yeah.
All right. Thank you, Your
All
Honor.
right, thank you. All right, Gustavo Devorah. All right, sir. You were arrested, sir, on a warrant. You do qualify for representation by the Public Defender's Office, and you are entitled to be represented by a lawyer. Would you like for me to appoint the Public Defender's Office to represent you?
Yes, sir.
All right, so I will do that. Mr. Thompson, do you want me to read the charge, or do you wish to waive reading?
We'll waive the reading of the charges, Your Honor.
All right. Sir, your bond on count 2 is $5,000. I've read the affidavit. Taking the entirety of the circumstances, I mean, they're serious charges, taking the entirety of the circumstances into consideration. However, I'm going to set bond at, on count 1 at $10,000 for a total of a $15,000 bond. You may not have contact with the alleged victim. Stater, I don't believe they reside together. Did you reside together, sir? He's shaking his head no. I didn't didn't appear to me that they did. Are there any other terms that the state would request other than no contact?
Not at this time, Your Honor.
All right. So to be very clear, no contact means you can't have a third party contact the alleged victim. You cannot contact by social media, by email, by text message, or any other means, okay? And I'm sure you've signed something that says you understand all that, so make sure you read it and understand it. If you have questions, you need to ask your lawyer, okay? Thank you, sir. All right, the next case, Terrence Givens. Good afternoon, Mr. Givens.
Hello, sir.
Sir, you were arrested for possession of cocaine. I reviewed the affidavit, and I do find probable cause. You're entitled to be represented by a lawyer, and you do qualify for representation by the Public Defender's Office. Would you like for me to appoint them to represent you?
Yes, sir.
All right, so I will appoint that office to represent you. And you do not, unfortunately, qualify for pretrial release, in part because of the number of failures to appear that you have. Your bond is $1,000. I'll stay at that amount, and the conditions of bond will be no possession or use of drugs or narcotics without a valid prescription. Okay?
Yes, sir.
Good luck, sir.
Thank you.
All right. Terrence Glasgow. Tell me how to pronounce your last name.
Glasgow.
One more time.
Glasgow.
Glasgow, okay. CH sounds like a K. All right, Mr. Glasgow. You were arrested, sir, for grand theft of a motor vehicle. I reviewed the affidavit. I do find probable cause. You're entitled to be represented by a lawyer. I don't see that you filled out an application yet, so I'm going to provisionally appoint the Office of the Public Defender to represent you. You don't qualify for pretrial release. Your bond is set at $1,000, and I will stay that amount. Anything further, counsel?
No, Your Honor.
All right, thank you, sir. Tyrone Grooms?
Yes, sir, Your Honor.
All right, good afternoon, sir.
How you doing?
So you're here on two cases. Case number 2021 CF 7606, you were arrested for burglary of a dwelling with an assault or battery. And another judge has found probable cause. There is currently no bond. State what's your position with regard to bond on that case.
Your Honor, given the history of the defendant, the state requests a high bond in this case.
Is the state requesting proof evident presumption great at this point or no?
I'm sorry, Your Honor, can you please repeat
Is
that?
the state requesting the court find proof evident presumption great at this point or no?
No, not at this point, Your Honor. Pending in Arthur hearing at a later time, please.
All right. All right, based on the circumstances and the allegations in the affidavit, I'm going to set bond at $50,000. Conditions of bond in this case will be no return to the location of the alleged offense, no contact with the alleged victim, no possession of weapons or firearms, no contact. I think I said that already. Okay?
Excuse me, Your Honor. I just wanted to, just bring to your attention that one of the charges is I just want to take back what I previously requested. I would like to ask the court for no bond in this case.
Well, all right. So this is a punishable by life offense, and there is an exception to entitlement to bond for life offenses. All right, so I'll rescind the bond. This can be set for a bond hearing before the division judge.
Your Honor, could I be heard as to bond?
Sure.
Okay, if the state's asking for a finding of proof evident presumption of great, that's going to be a higher standard than not only probable cause, but proof beyond a reasonable doubt. If you're looking at the arrest affidavit or the probable cause supporting document to issue the arrest warrant, it mentions possible multiple witnesses, but the affidavit doesn't have any written statements from the witnesses or what those witnesses might have or may have not seen. Just mentions that they were probably there. The law enforcement officer in the arrest affidavit also mentions there might have been damages to the structures, injury to the alleged victim, and various things of that nature, but he didn't say that he actually saw them. There's no mention that the witnesses said that my client caused those injuries or my client was responsible for the damages to the structure, Your Honor. I do see that there is probable cause there, but I would ask the court not to find the highest burden in which you prove evident presumption great, just because of how the probable cause supporting document is written, Your Honor. And I would ask for you to reinstate the $50,000 bond or possibly a bond even higher.
Mr. Thompson, is there case law that says I have to either find proof evident presumption great at initial appearance or set a bond at initial appearance?
Per Florida, or Florida law, on the Florida Constitution, the court cannot hold a person at no bond unless the court finds that there's proof evident and presumption great. So you would have to make that finding before you are able to hold him at no bond.
Right, but is there anything that says I can't refer that matter to the division judge for a determination?
I believe it may be in your I believe from the way I read the statute, Your Honor, you have to make that finding, or you have to make the finding before you hold him at no bond.
Ms. Carrasco, do you want to respond?
Yes, Your Honor. Under Thurman v. Junior, Your Honor, the court is not required to make that finding at initial appearance.
What's the citation for that?
Oh, I'm sorry, Your Honor. That is 275 Southern 3rd, 726.
275, 7/3, 726.
Yes, Your Honor.
I'm not, what's the name of the case?
Thorman v. Junior.
Okay, Thornton versus Junior, okay. From the 3rd District Court of Appeal. Has that case been overruled by the Florida Supreme Court?
It has not, Your Honor.
Is there any contrary 5th District Court of Appeal case law?
I believe there is, Your Honor, the 4th DCA.
No, the 5th. Is there anything?
Oh, no,
from
there
the
is
5th?
currently nothing out of that district.
Okay. This issue is pending in the Florida Supreme Court, isn't it?
It is, Your Honor.
Right, it's, the proof evident presumption rate is absolutely higher than beyond a reasonable doubt. There's no question about that. But this Thorntman decision talks about how it's difficult to make any kind of determination in the context of an initial appearance, and that it is not a two-step process, and that the court can simply order that a defendant be held without bond and require that the matter be set for an Arthur hearing before the division judge. The court concludes, we hold that Article 1, Section 14 of the Florida Constitution does not prohibit the trial court the discretion at first appearance upon a finding of probable cause that the defendant committed a crime punishable by capital punishment or life imprisonment to defer ruling on bail and to detain the defendant for a reasonable time to conduct a full Arthur bond hearing. So based on that authority and based on the fact that there's a conflict, and the 5th District has not passed on the issue, I am going to follow Thorntman and order that Mr. Grooms be held without bond pending a full hearing before the division judge. Based on the nature of the charge, which is one of the reasons I was setting a higher than usual bond anyway, before the state asked the court to reconsider.
And Your Honor, for the record, the defense makes no argument for proof evident presumption grade, and we do reserve that right to make that argument in the trial division at the Arthur hearing, Your Honor.
Absolutely.
Thank you very much.
Thank you. All right, and then Mr. Grooms, in 2021 MM 7679, you were arrested for resisting an officer without violence. There is probable cause after reviewing that affidavit as well, and your bond in that case is set at $500. And I'm going to, you qualify for representation by the Public Defender's Office. Forgive me if I've already asked you. Would you like for me to appoint that office to represent you?
Yes, Your Honor.
All right, so
I don't know.
So in both cases, I'm going to appoint the public defender to represent you, sir.
Your Honor, can I have a moment to confer with my client?
Sure.
What case is it?
Thank you, Your Honor.
Thank you. All right, Hermano LaPree Hall. Good afternoon, sir.
Excuse me.
So you were arrested for possession of cocaine.
Yes.
I do find probable cause after reviewing the affidavit. You qualify for representation by the Public Defender's Office. Would you like for me to appoint that office to represent you?
Yes, sir.
All right, so I will do that. They are appointed to represent you, sir. I need to set bond in this matter. You have a number of failures to appear, unfortunately, so I'm going to leave your bond set in this matter at $1,000, okay? Anything further, counsel?
No, Your Honor.
All right, thank you. Mr. Hatmaker, Stacy Marie Hatmaker?
Bonded, Your Honor.
Who?
You bonded.
She bonded. Okay, yes, okay. Is this Mr. Heady? Michael Heady? All right, good afternoon, Mr. Heady. Mr. Heady, you were charged with burglary of a dwelling with assault or battery. I'm reviewing the affidavit. I do find probable cause. This is another case that is punishable by life, although the circumstances of this case did not involve the actual residence. State, what's your position with regard to bond on this matter?
State requests no bond pending an Arthur hearing at a later time, Your Honor.
All right.
Your Honor, for the record, the defense makes no argument as for proof of the presumption great, and we will reserve the right to make that argument in the trial division. However, if the court's inclined to set a bond, I would definitely have no objection.
Okay, thank you, sir. Mr. Heady, you're entitled to be represented by a lawyer. The clerk advises me, however, you do not qualify for representation by the Public Defender's Office, so you'll need to retain counsel if you wish to be represented by a lawyer. If your financial affidavit is incorrect, you can fill out another one. There is a statutory fee every time you complete one of those affidavits. You should keep in mind as well.
Your Honor, may I say something?
I don't want you to talk about your case, okay? Because we're being recorded and everything you
Most
say
likely, I
can be
probably
used
lost my
against you.
job. So I just started a new job. And I won't have no way to hire an attorney if I'm sitting in here.
Well, you'll need to fill out another application at some point then, and the court can appoint, if that's the circumstance, the court can appoint a public defender to represent you at that time, okay? But based on the information in this affidavit, you don't qualify, okay? So I am going to, because this case is a punishable by life offense, I am going to defer the determination of bond to the division judge. Okay? Thank you, sir.
Judge,
Oh, I'm sorry, Mr. Heady. Were there two cases?
I would like to say something, Your Honor.
This is first appearance, Mr. Heady. There is also a misdemeanor case, 2021 MM 523, trespass on property other than structure or conveyance. And there is probable cause, and you're entitled to be represented by a lawyer in that case as well. In that case, the bond will be $500.
I just don't understand where this other charge came from. I didn't do.
Don't say anything about the case.
Don't say anything, Mr. Heady. Fill out, if you think you qualify for the public defender, fill out another application so that the court can appoint one to represent you as soon as possible, okay? All right, thank you, sir. All right, Melissa Hodges.
Refuse, Your Honor.
She refused. We'll reset her for tomorrow.
Your Honor, the defense will waive her appearance.
Waive, okay. All right, so she was charged with possession of fentanyl, drug paraphernalia, and trespass on property after a warning. She has limited ties to the community, so the court is going to stay her bonds at $1,000 on count 1, $500 each on count 2 and 3. Court will provisionally appoint the Office of the Public Defender to represent her. All right, Corey Kennedy, is that you, sir?
Yes, sir.
Okay. Mr. Kennedy, you were arrested on a charge of failure to register.
Mm-hmm.
There is probable cause as found by the judge who issued the warrant for your arrest. He set your bond at $2,500. I'm going to stay the bond at that amount. Okay? Look at your affidavit here. So you qualify for representation by the Public Defender's Office. Would you like for me to appoint them?
Yes.
Okay, so I'm going to do that. Don't say anything about your case. It looks like you want to say something, but
Where I check in at.
Don't say nothing about the case.
He told me
You're being recorded. Don't say anything about the case. Go ahead, say what you want to. Go
I
ahead.
took the house, they locked the doors, and that's why I didn't register. When I went yesterday to register, he told me that if I would have came and just registered and told him that I was homeless, like I just did yesterday, I wouldn't even went to jail. So he just basically told me when I get out today, I'm supposed to just come back to him because I just didn't know what to do after my mom passed and they locked the house with all my key, my clothes, and everything in the house. I don't have anything.
all right.
Hey, Your Honor, for the record, the statements that my client just made was despite my legal advice to remain silent.
Absolutely, and he was advised multiple times not to say anything. So, Mr. Kennedy, I appointed the public defender to represent you. Hopefully, they can work something out with the state, okay, under the circumstances, but that's not something that we address at first appearance, all right? So your bond is $2,500, and you're represented by the public defender's office, okay? And conditions of bond are that you register as required, okay?
So
Thank you, sir. All right, Mr. Kirkins, tell me how to pronounce.
No, he refused.
He refused, okay.
Defense will waive his appearance.
All right, so Mr. Kirkins, charged with possession of a firearm by a convicted felon. His bond is stayed at $20,000. Probable cause was found by Judge Shoemaker when he issued the warrant. Conditions of bond will be that he not possess any weapons or firearms, which of course would be a new law offense if he did. All right, I don't have an affidavit, so I will provisionally appoint the Office of the Public Defender to represent him. All right, and who is this?
Stephanie Lampleyon, Your Honor, mental health.
Okay.
Defense will waive her appearance, Your Honor.
Okay. All right, so Ms. Lampo was arrested for aggravated assault with a weapon. Probable cause has previously been found. Her bond is set at $2,500 with the conditions: no contact with the victim, no return to the scene. The bond amount will be stayed. Additionally, her ROR in case number 2021 MM7328 will be revoked and she'll be held on zero bond in that case. Okay. And this is Mr. Langston. Are you Mr. Langston? Lawrence, okay. What happened to Mr. Langston? I'm I'm sorry? His booking number. 210-5329.
You said 210?
210-25329.
And you said Langston last name?
Yes. Okay, excellent, thank you. All right, Mr. Lawrence. Sir, you were arrested for burglary of a structure and grand theft in the second degree of $20,000 or more. There is probable cause based on my review of the arrest affidavit. I've reviewed your application and you do qualify for representation by the Public Defender's Office. Would you like for me to appoint that office to represent you? Yes? All right, so I will appoint the Public Defender's Office to represent you, sir. You do qualify for pretrial release. All right, based on the fact you have no prior failures to appear, I'll grant release on pretrial release. Conditions of bond will be that you not return to the location of the alleged offense, and you have no contact with the alleged victim or employees of the alleged victim. Okay? Thank you, sir. Mr. Owens?
Yes, sir.
All right, good afternoon, Mr. Owens.
I'm sorry, Your Honor. Did we address the Mr. Lawrence's criminal mischief charge?
I'm sorry? Oh, he has a second case? I'm sorry. I didn't make a note that he had two. I guess I... All right, so Mr. Lawrence, I overlooked a second case. So the case we just talked about was 2021 CF 14139. You were also arrested in case number 2021 MM 7683 for criminal mischief. Again, I'm granting pretrial release subject to the same conditions announced before, and the Public Defender's Office will be appointed to represent you in the criminal mischief case as well. And finally, there is probable cause based on the information in the court file and in the affidavit. Okay? Thank you, sir. All right, now, Mr. Owens, take a look. Mr. Owens, you're entitled to be represented by a lawyer. You do qualify for representation by the Public Defender's Office. Would you like for me to appoint that office to represent you?
Yes, sir.
All right, so I'll appoint the Public Defender's Office to represent you. So you were charged. Counsel, do you wish to waive the reading of the charge?
Yes, Your Honor.
All right, so I'll waive the reading of the charge and state.
Your Honor, the state at this time asked for no bond in this case pending an Arthur hearing at a later time.
Counsel?
Yes, Your Honor. Defense makes no argument as to proof of the presumption great, and we reserve the right to make that argument in the trial division.
All right, thank you. All right, so as stated in the earlier cases, this case is subject to the Arthur standard, so the court will defer that standard to the court because I have determined that there is probable cause based on the affidavit to support the arrest. All right, so Mr. Owens will be held on zero bond until the matter can be set before the division judge. Okay, thank you, sir. Yes, sir.
What was this court session about?
This is the first appearance, your initial appearance, to advise you of the charge and to address release conditions and things of that sort.
What is the charge?
You can talk to your lawyer about it. He waived the reading of the charge. He'll show you.
New charge?
To make an argument and for the actual case, whether to do it or not, it's called an argument. The plaintiff can then have the case and I'll get with you and then I'll tell you all about it. Thank you, Your Honor.
Thank you. All right, Mr. Rivera.
Yes, Your Honor.
All right, Mr. Rivera, you were arrested for aggravated assault with a deadly weapon on counts 1 and 2 and improper exhibition of a weapon or firearm in count 3. Another judge found probable cause and set your bonds at $2,500, $2,500, and $500 for a total of $5,500. I'm going to provisionally appoint the Office of the Public Defender to represent you. You're entitled to be represented by a lawyer. You can hire private counsel if you wish, or if you complete an affidavit and if you qualify, the court will appoint the public defender to represent you. Don't talk about your case. What's your question?
Your Honor, can you have the state look up the charges that they have been dropped within this month?
State, what do you know about that?
Your Honor, I don't have any information at
Did the
this time.
state null pros? The state filed the information, so if the state's who can drop them.
No, they picked me up on a warrant last night. And on the warrant, Your Honor, it's from a case that already has been closed. And I had a public defender on this case. And she had called me and had let me know that the state had dropped the charges on me.
All right, Madam Clerk's looking at the court file now. All right, so the information was filed October 7th? Yep, so the case is still pending, sir. Okay? All right, thank you. All right, Sergey, how do you pronounce your name?
Refuse, Your Honor.
He refused, okay.
Defense waives appearance.
All right, so I'm not sure how to pronounce it. Oh, it's a Latin name, so it would be Jorge Sergey, I think. He was arrested for aggravated assault with a weapon and petty theft, 2 prior theft convictions. I will provisionally appoint the Office of the Public Defender to represent him. There is no affidavit yet in the court file with regard to indigency. All right. I reviewed the affidavit. I do find probable cause. I'm going to stay the bonds at the amount of $2,500 on count 1, $500 on count 2. He is out on bond in case number 2018 CF 4790. That bond will be revoked, and he will be held on zero bond on that case. All right, and then he was arrested for possession of drug paraphernalia in 2021 MM7688 following his arrest in the first case, and there is probable cause based on the affidavit in the court file, or not, yeah, the arrest affidavit. And I will provisionally appoint the Office of the Public Defender to represent him in that case as well. And his bond is, great minds think alike, right? His bond will be stayed at $500.
Is that fine?
Yes. All right, Mr. Mosby, is that you, sir?
Yes, sir.
All right, sir. In this case, you were arrested for a moving traffic violation operating a motor vehicle without a valid license. This case number is 2021 CT 1886. You're entitled to be represented by a lawyer. The clerk advises, however, that you do not qualify for appointment of the Office of the Public Defender. Your bond is set at $500. You do not qualify for pretrial release, so I'll stay the bond at $500. So you're out on pretrial diversion in case number 2021 CF 4352. Based on the nature of the new charge and the nature of that charge, I am not going to revoke your release on that. Okay? Is there a motion? I'm not, yeah. No action on the pretrial diversion. Based on the nature of the new charge and that charge, I'm going to...
Can I say my speak, please?
Don't talk about your case, okay? What's your question?
I just didn't have any money right now to be released, and I'm gonna lose my job because I'm working right now because they had me on the hold, and I completed I had completed everything as far as that older case, and my public defender told me about watching the video and paying $100, and I watched the video, and I got like $50 more to pay.
Right. And I did not revoke your bond, so I mean, I did not revoke your release in that case, but you do have a bond in the new case.
Could I be, I'll go to court every time. I never missed a court date, Your Honor.
Did he not qualify for PTR because of the diversion? Was that the reason?
Because he had an open case, yes, sir.
Because that, if I can speak it one more time, they had dismissed that case was over when I talked to my public defenders.
It's not over if you still owe some money.
Okay, because he didn't explain that right to me then.
Well, that's what, I think that's what your contract probably says, yes.
He also has an open case in Michigan, so that was another reason why he didn't qualify for PTR.
Okay. All right, so sir, that's, it's a $500 bond. That's a very reasonable bond, okay? All right, thank you. Mr. Ortiz?
Yes, sir.
All right.
Good afternoon, sir.
Good afternoon, Mr. Ortiz. Sir, you were arrested for failure to appear, and a warrant was issued, or a capias was issued, and you have a bond in that case of $250. Okay. You're entitled to be represented by an attorney, and you do qualify for representation by the Public Defender's Office. Would you like for me to appoint that office to represent you?
Yes, sir. Please.
Okay, I'll appoint that office to represent you, sir. Okay? Anything further, counsel?
No, Your Honor.
All right, thank you, sir.
Speak, sir.
There's really nothing to talk about, sir, because the judge set your bond, and that's what it is. Okay? All right. Ms. Velez? Nope. What happened to Ms. Velez?
Excuse me?
Priscilla Velez? I'm sorry? 210-25332. 332.
Priscilla Velez?
Yes.
Find it.
Excellent. Okay, thank you. And you're Mr. Jones?
Yes.
Okay.
Your Honor, would you have any objection to an ROR in this case? He's charged with possession of cannabis less than 20 grams. I thought they stopped arresting for this offense, but he'll qualify for a pretrial diversion in the child division or a credit time served offer, Your Honor.
Let me take a look and remind myself of this.
It's less than 20 grams.
Right, he was the passenger. He was not the felony suspect that led to the stop. Is that correct?
Yes, I believe so, Your Honor. There might be a constructive possession.
State, do you have any objection to an ROR?
No objection, Your Honor.
All right, so you're entitled to be represented by a lawyer, and you qualify for representation by the Public Defender's Office. Would you like for me to appoint that office to represent you?
Yes, sir.
All right, so the paperwork I have says you live in Houston.
Yes, sir.
So are you going to be going back to Houston?
Yes, sir.
When?
Probably as soon as I get out of here next day, or after I get out of here, as soon as I get out of here.
You have relatives here?
Excuse me?
You have relatives here?
Relatives? Yes, sir. I do have relatives here.
All right, so if you have a court date in the future, you'll be able to return to Orlando to address your case?
Yes, sir. Absolutely.
All right, I don't see any failures to appear. You're in college. You're currently attending school?
Yes, sir.
So you need to get out so you can get back into class, right?
Yes, sir.
All right. All right, based on the circumstances, I will grant ROR. There is probable cause based on the affidavit in the court file. I keep saying in the court file, but in the arrest affidavit, I assume it's in the court file by now. But there is probable cause. And I have appointed the public defender. Anything else, counsel?
No, Your Honor.
Okay, thank you, sir.
Thank you, Your Honor.
Thank you. Mr. Narves? All right. Do you pronounce your name Narves?
Yes, sir, Narves.
Okay. So you were arrested for trespass on property after warning. There is probable cause based on the affidavit of arrest. You qualify for representation by the Public Defender's Office. Would you like for me to appoint that office to represent you?
Pardon me?
You're entitled to be represented by a lawyer, and you qualify for representation by the Public Defender. Would you like for me to appoint his office to represent you?
Yes, please.
Okay, so I'll appoint that office to represent you. All right, so as I said, there is probable cause. I've appointed the public defender. All right, I'm going to stay the bond at the amount of $500. And the conditions of bond will be not to return to the location of the alleged offense and no contact with the owner of the owner and occupant of the location of the alleged offense. Okay? All right, thank you, sir. David Rogers?
Yes.
All right, sir. Rogers, you were, well, let me skip ahead. You're entitled to be represented by a lawyer, and you do qualify for representation by the Public Defender's Office. Would you like for me to appoint that office to represent you?
Yes.
Okay, I will do that. Mr. Thompson, would you like for me to waive the, or would you like to waive the reading of the charge?
Yes, Your Honor.
All right. So, Mr. Rogers, if you want to discuss the nature of the charge, you can visit with Mr. Thompson about that, okay? There is probable cause based on my review of the affidavit, and your bond is set at $500. You do not qualify for pretrial release. And you do have a prior failure to appear, so I will stay your bond at that $500 amount, okay?
And Your Honor, can we also possibly have on screen for mental health pretrial release? So if he qualifies, he could be released under there, and if not, the bond could stay?
Does he qualify for mental health pretrial release? It'd have to be screened, okay. So what I'll say is he can be released on mental health pretrial release if he qualifies. Otherwise, it'll be the bond. And the conditions are not to return to any place where children congregate. Okay, thank you, sir. Are you Mr. Scarborough?
Sir.
All right, sir. You were charged, sir, with possession of drug paraphernalia. It looks like you have a couple of cases, Mr. Scarborough. You were charged with possession of drug paraphernalia. There is probable cause based on my review of the affidavit in the court file. You're entitled to be represented by a lawyer. Would you like for me to appoint the Office of the Public Defender to represent you since you qualify?
Yes, sir, and I'd like to resolve this today if possible.
Well, I'm not going to resolve this charge today, but so I'll appoint the Office of the Public Defender to represent you. I'm going to set your bond at $500 or stay the bond at that amount, and you may not use drugs or narcotics without a valid prescription. Then also you were charged, sir, with violation of a municipal ordinance of an open container. Since I'm not resolving the other case today, I'm going to let this one follow along that one as well. The bond in this case is $250. And I'll appoint the public defender to represent you in that case as well. All right, counsel, anything further from Mr. Scarborough?
No, Your Honor.
Okay, thank you, sir. All right, Mr. Volcker.
Yes, sir.
All right, sir. So you were charged with trespassing, failure to leave property upon order by owner. You're entitled to be represented by a lawyer. I don't have an affidavit, so I'm only going to be able to provisionally appoint the Office of the Public Defender to assist you currently, but I'll do that.
Can I plead guilty to this today? I'm on vacation and I got thrown off the Amtrak and I didn't move fast enough. I wasn't listening.
I'm aware of what the allegations are, sir. I do find probable cause. No, we're not going to resolve this case today based on the nature of the charge. Okay, your bond is set at $500. All right, and all right, counsel, anything further?
Your Honor, if he wants to resolve this case, if you have no objection to it, you could roll this case until Monday and let one of the judges who usually do this during the week, they will probably plead this case out if he so desires.
I'm sorry? Yeah, okay. I would suggest you all try to get it teed up in front of the division judge.
Okay.
He does have a fairly reasonable bond, and I'm staying it at $500, even though he is not in a Florida resident. The bond schedule suggests it should be
higher,
doubled. Okay?
Thank you, Your Honor.
All right, thank you.
We'll get you a court date. Monday? No, I said we'll get you a court date. No, we'll be before that.
All right.
Thank you, Your Honor. Sorry.
Thank you. All right, so Mr. Rakovic? I'm sorry?
Excuse me?
What's your name? He's medical. Do we need to reset it for tomorrow? It's an out-of-county and an well, there's an outstanding one in Colorado too. So. Yeah, let's reset it for tomorrow, just to see. So are you Mr. Xavier?
Yes, sir.
Okay. Mr. Xavier, you were arrested on an out-of-county warrant for aggravated battery on a pregnant woman. There is no bond on that, so you'll be transported to Lake County to address that.
Excuse me, Your Honor. That charge is a whole mistake. That charge is supposed to already have been thrown out.
Well, you'll have to address that with Lake County. It's a warrant.
I already have the paperwork process. That charge was already, as far as I knew, that charge was already dismissed.
Well, all I know is that you were arrested on a warrant, and the warrant was, as of yesterday evening, still there, and there's no bond, so you'll have to take that up in Lake County. I'll provisionally appoint.
How long?
No, that's a Lake County issue, so they'll have to appoint the public defender. So you're also out on bond in case number 2020.
That's my thing.
F14751, and so that bond's going to be revoked, and you'll be held on zero bond in that case. Okay? Counsel, do I need to appoint this? Since this is an out-of-county warrant, I would not appoint your office to provisionally, would I?
I'm not sure how they do it down.
I don't think we're still doing that.
Okay.
In the COVID protocols.
Yes.
So, Mr. Xavier, what's your question?
Okay. Yeah. The Lake County case is supposed to have already been dismissed. Is there any way we could contact the alleged victim or anything like that to confirm that?
No, we gotta do that in the trial division, so someone.
Today's not the day we do that.
I understand that, but what you're saying is my other bond is the bond that I'm out on is being revoked today, correct?
Correct.
That's really a big problem. I have a new.
Well, the lawyers will be working on it. You have a lawyer in the other case. You should have a lawyer in the Lake case. If you don't, you will be getting one, and they'll get it all resolved for you. But that's not something I can address today.
I have a newborn baby that needs me right now. It's not.
All right. It's not the purpose of today, sir. Okay? I did not, since it's an out-of-county warrant. All right, Mr. Clark?
Yes.
How you doing, sir?
Okay.
Good deal. Sir, you were charged with disorderly conduct in violation of a municipal ordinance. There is probable cause. You do qualify for representation by the Public Defender's Office. Would you like for me to appoint that office to represent you?
Yes.
Okay.
Your Honor, I would ask for this case to be, if.
You want to resolve it today? Is that what you're?
Well, that's my notes, but if you didn't want to resolve it, we could, reset it till Monday, or I would ask for him to be released ROR.
I have a note that it is a possible resolution today.
Me too.
I didn't resolve the other one because there was a first-degree misdemeanor along with it. So I don't resolve those, but I have no problem resolving a municipal ordinance.
Okay. I believe I have the plea form here.
All right.
I'll just sign it real quick. I have one. All right.
Mr. Clark, would you raise your right hand? I'm going to put you under oath. Do you solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Thank you, sir. Did you sign that form, sir?
Yeah.
Okay. Mr. Clark, tell me your name.
Marcellus Clark.
And Mr. Clark, are you under the influence of any drugs or alcohol or prescription medication today?
No.
Have you ever entered a plea agreement before?
Yes.
Okay. And are you able to read and understand English?
Yes.
How many years of school do you have?
12.
Okay. And the document you just signed, do you have any questions about that document, sir?
No.
All right. And are you on probation for any other case?
No, sir.
Do you have any questions about the rights you'd be giving up by entering a plea in this case?
No, sir.
And do you understand that if you're not a U.S. citizen, entry of the plea in this case will result in your deportation?
Yes.
And you understand, sir, that no one can force or threaten or coerce you to enter a plea?
Yes.
So are you entering this plea voluntarily of your own free will?
Yes.
And I think that's probably good enough for today's purposes, sir. So you were charged, sir, with violation of a municipal ordinance prohibiting disorderly conduct. How would you like to plea?
No contest. No contest.
And are you entering that no contest plea because you believe it's in your best interest to do so?
Yes.
All right, sir, I'm going to find you're competent, coherent, and alert, and that you have freely, voluntarily, and intelligently waived your rights. You've entered the plea knowingly, understanding the charge and the consequences. And there's a factual basis based on the affidavit in the court file. Mr. Thompson, do you stipulate to the factual basis as well?
Yes, for purposes of the plea, Your Honor.
Okay. Mr. Clark, is there anything you would like to say before I impose sentence?
No, sir.
All right. All right, sir, I'm going to adjudicate you guilty of the municipal ordinance violation. I'm going to sentence you to time you've served and give you credit for that time. What is that, 1 day?
Your Honor, I do believe the agreed upon resolution is a withhold of adjudication.
Is that correct, State?
According to my notes, it is, Your Honor.
All right, so I'll withhold adjudication then on that, and I will sentence you to the time you've served. Is that 1 day? 3 days. Okay, so you'll have 3 days credit for time served. And Madam Clerk, could you impose or announce the court costs? All right. And there is a $50 public defender application fee based on the affidavit. That's a matter of statute. Mr. Thompson, does your office request imposition of, I believe I'm required by statute to impose the minimum fee of $100. So that's what I'll do. I'll impose that $100 and actually it'd be a $50 public defender lien and a $50 cost of prosecution. And I will reduce those to civil judgment. And Mr. Clark, you have the right to appeal. Any notice of appeal has to be filed in writing within 30 days of today's date. The court would appoint a lawyer to represent you if you can't afford one. Okay, take care, sir. Mr. Sterrett.
Mr. Sterrett's medical, Your Honor.
All right, we'll reset Mr. Sterrett for tomorrow. You, Mr. Brown? All right, Mr. Brown, you were arrested on a warrant for violation of probation. Actually, it wasn't a warrant, it was an on-view violation of probation. There is probable cause. So you're entitled to be represented by a lawyer, and you do qualify for representation by the Public Defender's Office. Would you like for me to appoint that office to represent you?
Yes, sir.
All right, so I will do that. And since this is a violation of probation matter involving a new law offense, there will be zero bond, and you can take up the issue of bond with the division judge. Okay?
Sorry,
Thank you, sir. Yes, sir?
I'm sorry, I didn't hear you.
I said you can take up the bond issue with the division judge. Okay? Mr. Coward? Is that you?
Yes, sir.
All right. Sir, you were arrested also for a violation of probation. Judge Wilson issued a warrant for your arrest, and there is no bond. You do qualify for representation by the Public Defender's Office, and you are entitled to be represented by a lawyer. Would you like for me to appoint the Public Defender's Office?
Yes, sir.
All right, I'm going to do that now, and you can visit with your public defender about getting the matter before Judge Wilson, okay?
All right.
Thank you, sir. All right, Mr. Hines, is that you?
Yes, I was trying to get an early court date for my bail hearing.
All right. Well, today's the initial appearance, Mr. Hines, so I don't have any control over the court dates for the division judge. You were arrested, sir, for a violation of probation, and another judge issued a warrant for your arrest, and they have not set a bond for you.
I can't get no bond?
No,
Yeah, there is no bond.
You should.
You're entitled to have an attorney represent you, and you do qualify for representation by the Public Defender's Office. Would you like for me to appoint that office to represent you? All right, so I'm going to do that, sir. And it'll be up to your lawyer to get your case set before the division judge. Okay? Thank you, sir. All right, and then,
Whitmore refused. Defense to waive his appearance.
all right, so Mr. Whitmore was also arrested on a violation of probation. It was an on-view. It looks like there are a couple of cases. 2020 CF 292 and 2019 CF 12055. And there is probable cause. There is no public defender or indigency application, so I will provisionally appoint the office of the public defender. to represent him, and because it's a violation of probation in each case, he'll be held on zero bond. Also, he's a violent felony offender of special concern, so the division judge has no authority to grant a bond either. All right, what about Mr. Acevedo or Rosado?
Also refused.
He also,
Did you address two cases for Whitmore?
yes, I did.
Both of them, no.
Yes, well, because he's a violent felon offender of special concern, there can't be a bond, yeah. Thank you.
Defense waived Mr. Acevedo's appearance. And Your Honor, I know he has history, but no, never mind, Your Honor. Yeah, we'll the defense will waive his appearance and leave the matter of bond to the discretion of the court, Your Honor.
All right, well, this is one that could be resolved if he would come. Why don't we just roll it to tomorrow?
Okay.
All right. Acevedo? I believe this is one that I think would be resolvable. Yeah. So Mr. Acevedo Rosado will be rolled to tomorrow, and then Mr. Dennison.
Bonded.
Mr. Dennison bonded. Okay. You're not done with the interpreters. And Arlene would not have let me be done with the interpreters.
Good afternoon. This is Talia Romero, Spanish interpreter on the line, Your Honor.
Good afternoon. We have two individuals for first appearance. Are you still having allergy issues, Madam Interpreter?
Actually, yes, Your Honor, it turned out into a sinus infection.
Oh, no, I'm so sorry to hear that.
Lost my voice, and I'm not sure if we had an interpreter still available for you this afternoon. So I'm home and I have a computer at home, so I heard it and I answered.
Oh. Well, we had one this morning, but when I called back after the lunch break for the orange, no one answered, and I tried 3 different times.
Yeah, that interpreter was probably gone.
Okay. So do we need
I'm
to
here.
reset these because you've lost your voice?
No, Your Honor, I'm actually doing tomorrow as well, so I'll go ahead and take care of this for you.
Oh, thank you so much. All right, so this is Lisbeth Pacheco-Carabao. And the case number is 2021 CF 14159.
Your Honor, we're just gonna have to do it over the loudspeaker
Okay, that's fine.
because I'm not able to connect to the podium right now. I don't know why, but I can do it over the loudspeaker.
Okay. Was that the headphone making that noise?
No, unfortunately, my phone is going off. Can you give me 1 second, please? I'll turn it off.
Oh, okay.
Okay, Your Honor, I'm ready.
All right. Ma'am, you were arrested for the charges of trafficking in oxycodone of more than 20 grams and less than 100 grams.
Señora, usted fue detenida y arrestada por tráfico de oxicodón, más de 20 gramos, pero menos de 100 gramos.
You were also arrested for possession of alprazolam.
También fue arrestada por tenencia de aprasalán.
I have reviewed the affidavit of arrest, and I do find probable cause.
Yo he repasado la affidavit de arresto y hallo que hay causas que respaldan la acusación.
You are entitled to be represented by a lawyer, and if you qualify, the court can appoint the Office of the Public Defender to assist you and represent you.
Usted tiene el derecho de ser representada por un abogado y si no puede pagar por un abogado, uno se le puede asignar de la Oficina de Defensores Públicos para que le represente.
I'm going to provisionally appoint the Office of the Public Defender to represent you until you decide whether you want to hire private counsel or seek appointment of the Public Defender's Office unconditionally.
Provisionalmente, señora, se le va a asignar la Oficina de Defensores Públicos para que le represente. En caso que usted decida contratar un abogado particular o no, va a tener representación legal por el momento.
State, the bond in this case is exceptionally high. What's your position with reducing the bond?
El juez le está mencionando a la fiscal. La fianza en este caso es bastante alta. ¿Cuál es la postura de la fiscal en cuanto a la fianza?
Your Honor, state does not object to a reasonable bond. I'm sorry.
Su señoría, la fiscal no objeta a que se le dé una fianza razonable.
Based on the charges and the amount of the drugs, what is the state's position as to what constitutes a reasonable bond?
Basado en la acusación y la cantidad, ¿qué piensa la fiscal que es una cantidad razonable para la fianza?
State would leave it up to the discretion of the court, Your Honor.
La fiscal lo deja a la discreción del juez.
All right, Mr. Thompson, do you want to be heard?
Yes, Your Honor. Client's 41 years old. I only see one felony conviction, minor arrest after that. I would just ask for a bond in the amount of $10,000.
El juez le ha preguntado al abogado Thompson y él dice que la acusada tiene 41 años de edad, solamente ha sido condenada de un delito grave y un arresto de un delito menor y está pidiendo que se le dé una fianza de $10,000.
And if the court is inclined to issue a lower bond, we have no objection to that as well.
Y claro, si el juez está dispuesto a imponer una fianza más baja, no objetamos a eso tampoco.
All right. Based on the affidavit and based on the fact that the prior conviction is 10 years ago, although it was another drug offense.
Bien, basado en la affidavit y la realidad que el otro caso fue de 10 años atrás, aunque fue el mismo tipo de caso.
And based on the prior arrest history, it doesn't look like there's a history of trafficking.
Y basado en el historial de arresto, no pareciera que hay un historial de de tráfico.
I'm going to reduce the bond on count one to $25,000. And I'm going to stay the bond on count two at $150.
La primera causa se reduce la fianza a $25,000 y en la segunda causa se mantiene la fianza igual que son $150.
Condition of the bond will be no possession or use of drugs or narcotics without a valid prescription.
Condiciones de la fianza es que no puede usar, poseer drogas ni narcóticos a menos que tenga una receta válida.
All right, anything else, State?
¿Algo más del fiscal?
Nothing further, Your Honor.
Anything else, Mr. Thompson?
No, Your Honor.
Thank you. Okay, thank you, ma'am.
Gracias, señora.
All right, and then we have Mr. Vasquez-Rosado, 2021 CF 14153. Sir, you were arrested for grand theft of a motor vehicle.
Señor, usted fue arrestado por hurto cuantioso de un vehículo motorizado.
Sí, eso dicen, señor.
¿Perdón?
Sí, eso dicen, señor.
Yes, that's what they say.
Okay, thank you, sir. I've reviewed the affidavit, and I do find probable cause to find that supports the arrest.
Yo he repasado la affidavit acusatoria y hay causas que respaldan la acusación.
Sir, you are entitled to be represented by a lawyer, and if you qualify, the court will appoint the public defender to represent you.
Señor, usted tiene el derecho de ser representado por un abogado y si es elegible, se le puede designar el defensor público para que le represente.
I will provisionally appoint the office of the public defender to represent you now.
Provisionalmente yo le estoy designando la oficina de defensores públicos para que le represente en este momento.
Sir, you're out on bond in case number 2020 CF 4230. The court will revoke that bond and set it at 0.
Señor, actualmente usted está bajo fianza en el caso 20 CF 4230. En este momento se revoca esa fianza.
All right, anything further, counsel?
No, Your Honor.
State?
Your Honor, could you please repeat the amount of the bond for the charge?
Yes, I'm sorry. So the bond on case number 2021 CF 14153 will be $3,500. And the conditions of the bond will be no contact with the alleged victim.
Bien, la fianza en el caso 21 CF 14153 son $3,500. Una de las condiciones es que no puede tener contacto con la alegada víctima.
Okay, thank you, sir.
Bien, gracias, señor.
All right, I believe that concludes our docket. Everyone have a great evening, and we'll be adjourned.